Good morning. This is Brenton Begley with the Elder Law Report. And today I want to talk about something that is incredibly important planning tool that a lot of people don't understand, and that is trust. So likely heard about trust, likely have heard that they can help plan for the future, help consolidate assets, those types of things. But there's a lot of mystery surrounding trust. And the reason why there's a lot of mystery surrounding trust, number one, is because I don't think people explain them well. And number two is they can be used for so many things, which is one of the benefits of a trust, is just the amount of utility, the amount of flexibility that they provide an estate planning attorney, and obviously any individual who wants to set up a trust. So the first question is, what is a trust? A trust is an entity, okay? It's something you create that's kind of like a person, and it can hold assets just like a person can own assets, right? So if you put something in a trust, then what you're doing is you're transferring ownership of that particular asset to the trust. So the trust now owns that asset. And so just like a corporation or any other type of business can own assets, so too can a trust own assets. And this comes from an old concept. So trust originated in medieval England. And back in the feudal times when they had, a king that actually ruled, and parliament that was vying for power with the king. And so, back in those days, they kind of, evolved a lot of well, not kind of, they absolutely evolved a lot of the rules of law that we just take for granted nowadays, like things like wills, things like being able to leave behind property, and things like trusts. So trusts were created because, maybe someone, a landowner, wanted to ensure that his assets passed to his firstborn, for example. Maybe he didn't want his assets going through some other type of feudal law upon his death. So back in the day in England, if you went off to war and you died, if you're a landowner and you own property, the state, the king, the monarchy, could determine what happens to that property based on the rule of law at the time. And perhaps that landowner did not want that to happen. Perhaps they wanted that property to go to someone other than what the king or the state wanted that property to go to. So what they would do is they would place their property, their assets, in trust with an individual called a trustee. So basically they would transfer ownership to that person, that trustee, with directions as to what to do with that property if they were to die, if they go off in battle. And so that trustee held that property and knew that if they came back, they just transfer ownership right back. Okay, and hence the name trustee, right? They're trusted individual to do what is said or what's requested of them. So number one, hold the property and then give it back if they return alive, and then give it to the proper person if they were to pass away. So this concept evolved into an actual real legal concept of, okay, well, we can now pre-designate what happens to our assets. Okay, so we own a lot of stuff. When I say assets, I mean home, real property, personal property like vehicles, trailers, household furnishings, clothing, things like that. All these things are assets, and all of them can be owned by an individual, so they can also be owned by a trust. And so what we have now, what's evolved from that medieval concept, is the ability for a legal entity to be created, and for that property, those assets to be transferred to that legal entity. Now, you still have a trustee. So whenever you set up a trust, the parties to a trust are, number one, the grantor, the person who creates the trust, or the trust maker. Those names are interchangeable. You have the trustee, okay? The trustee is the person who administers the trust. They manage the trust. They're who holds the property in trust and determines what happens to the property based on the terms of the trust that you set forth as the grantor. And then you have the beneficiaries. That's number three. Okay, beneficiaries can be lifetime beneficiaries, meaning that they can receive something from the trust during the lifetime of the person who made the trust. Or they can be death beneficiaries, meaning they don't get anything until the person who made the trust died. Okay, so those are the parties to the trust. So you still transfer the property to a person, the trustee. Now, the trustee conceivably can be you. So this brings me to the types of trust we deal with, right? There's two main types of trust. So every trust is either falls under one of the two categories. So there's revocable or irrevocable trust. So let's start out with the revocable trust. So the revocable trust, typically the trustee is the same person who makes the trust. So the grantor and the trustee, the trust maker and the trustee, are the same person. So essentially what you're doing is you're transferring the property into trust, but to yourself in your capacity as your own trustee. And this might sound a little bit confusing, like, wait, what do you mean you're transferring the property to yourself? How's it in trust? But think of it like this. If you created a corporation and you're the president of that corporation, also the founder of that corporation, and you give property to that corporation or sell property to that corporation, well, that corporation owns that property now. And it doesn't matter that you're the president. It doesn't matter that you ultimately have control over what happens to that asset that you transferred to the corporation. You still transferred ownership to another entity. Same thing with the trust, especially the revocable trust, right? So in a revocable trust, typically the trustee is the same person who creates the trust. And the reason behind doing that is because you want to maintain all power and control over the assets that you put in the trust. And the benefit of doing that is obviously you have power and control over the assets. You can ultimately dictate what happens to those assets that you put into the trust, and then you can take the assets out of the trust if you wish, sell the assets out of the trust, whatever. And you're the only person that needs to sign off on that as trustee unless you have a co-trustee. So that being said, that is the trustee role in a revocable trust. So what else does a revocable trust do? So any trust, including the revocable trust, allows you as the person putting stuff in trust, as the grantor, to consolidate all of your assets into one place. Now, this might beg the question, why would you want to do that? Well, if you have a bunch of different assets, so if you have personal items, vehicles, trailers, bank accounts, real property, these things must pass to your heirs whenever you pass away, okay? And the way that that happens is based on the way you set it up during your life. So let's say that you have a will. Let's say you just have a will. You say, okay, I got a wife, 3 kids, I got a husband, 3 kids, whatever. I'm going to leave everything to, my spouse or my children. And let's just use children because that's easier. Let's say I'm going to leave everything to my 3 children. So if you just have a will and then you pass away, what's required for those assets to pass to those children is they have to go through the probate process. They have to take your will down to the courthouse, file it with your death certificate. They have to prove who you were, that you passed away, when you passed away, who your heirs are, what your will says, whether or not the will is validly executed, what assets you had, what, creditors you may have owed money to. And that's a very important point, because if you have any creditors, any medical creditors like nursing home bills, Medicaid, trying to come back and recoup any money that they paid out for like nursing home care or something like that, probate is the opportunity for them to go after that. So not only is probate a long, difficult and expensive process, it's also the opportunity for creditors to go after the assets that you're leaving behind for your loved ones. So what you would rather do is to have those assets pre-designated. And if they're pre-designated to pass, then they pass just like that, outside of probate, to your loved ones. And you don't have to go through some long, drawn-out, expensive probate process. So what the trust does is anytime you put assets in the trust, again, it pre-designates what happens to those assets, because trusts have terms of distribution. So essentially, when you put things in trust, you've already set up the trust to say, okay, hey, look, put all the stuff in trust. So anything I put in my trust, if I die, this is how it goes. Right? Sally gets this, Charlie gets this, Amy gets this, whatever it is. And because you have those terms of distribution in the trust, and the trust holds those assets and by all intents and purposes owns those assets, then you've already pre-designated what's supposed to happen. So you get to avoid probate, which is huge. I mean, takes away a lot of heartache, a lot of pain and suffering, a lot of opportunity for litigation, and a lot of opportunity for heirs trying to fight and challenge what's going on in a will in the probate process. Okay, so that's the revocable trust. It's essentially an entity that you create to consolidate all of the assets that you have, to pre-designate what happens to them if you were to pass away. Okay, and let's just remember that you retain all control, power, and dominion over those assets if you are the trustee, which you can be in a revocable trust. And then you can revoke it at any time, hence the name. Okay, that being said, what about an irrevocable trust? So an irrevocable trust is very similar to a revocable trust, except for you nor your spouse can be the trustee. So for it to truly be irrevocable, meaning you can't revoke it, you can't be the trustee. So when you transfer the assets to the trust, you transfer ownership to the trust, but you lose a measure of power and control over those assets. Okay, so with everything in life, there's a little bit of give and take. Now you lose a measure of control over those assets, and I say a measure of control because it depends on who you appoint as your trustee, right? I know if I appoint certain people as my trustee, then certainly I'm going to still have power over the assets that I put in irrevocable trust by virtue of the fact that I have a certain relationship with that person that I've appointed as trustee. So let's say I made my brother my trustee. Well, my brother's going to do whatever it is that I say with regard to the property. Now, legally, the way it's set up is I don't actually have a say as to what happens to the property after, I've set the trust up already, okay? But I do get to set the rules of the game. This is another important point about the power that you still have with the irrevocable trust. A lot of people look at the irrevocable trust and it scares them because they think, oh God, I'm not gonna have power over my assets anymore. But an irrevocable trust is something that you create. So it's like if we were to sit down and play a game and I let you set up the rules for the game. You set up all the rules for the game. And then I say, okay, once the game starts, we can't change any of the rules. We have to lay out all the rules beforehand. Well, even though you can't change the rules during the actual play of the game, being the person who creates the rules in the first place is a big deal, and that affords you a lot of power when you set it up. Okay, so the same thing with the irrevocable trust. You set the rules of the game, and then you set that person in place to make sure that those rules are followed out properly. So with an irrevocable trust, again, you transfer the assets to the trust. You no longer own those assets. So even though you give up a measure of power, you get something in return because you no longer own the assets that you transfer to the trust. You have a protection for those assets because your liability no longer imputes to that asset that you transferred to the trust. So let's take a hypothetical situation. So let's say that you put assets in the irrevocable trust and then you get sued and you lose the lawsuit for whatever reason, right? So they're going to go after you and place a judgment on your property, except you've actually transferred everything to an irrevocable trust. So therefore, you don't own anything for them to place a judgment on. So everything that you own is free and clear of any liability that you've, gained through that being sued process. Now, that's huge. I mean, that's a really big deal. So let's take another hypothetical. Let's say that you need some type of long-term care, which is likelihood because any of us, right, have a 70% chance of needing some type of long-term care at any point in our lives. That's a big deal because that means you have a 70% chance of paying anywhere from $5,000 to $10,000 a month for long-term care. So if that's the case, and we're like, man, okay, well, I would like to not have to pay that level of care, so I'm going to do some planning. Part of the planning involves me transferring assets to an irrevocable trust. Let's say that's the case. Let's say you say, okay, well, I don't want to have to pay for that care. I want Medicaid to pay for that care because I've paid in Medicaid my whole life. I should be able to get Medicaid to pay for my care. That pot of money that I've been chipping into, they should be paying for my care. So Medicaid is something you have to qualify for. So if you're over-resourced, if you have too many assets in your name, you won't qualify for it. However, if you've already transferred all of your assets within a certain amount of time to that irrevocable trust, then you don't own any of those assets. So therefore, none of those assets count against you when trying to qualify for Medicaid. Here's the other thing. Medicaid is a bit of a double-edged sword in that if you do qualify, they will pay for your care, long-term care. And they'll pay as long as you are in long-term care and still qualify. So let's assume that you're in long-term care for a very long time and they end up paying out $500,000, $600,000 for your care, which is a real number. I mean, that happens to many, many people. So let's say that that's the case and they end up paying $500,000, $600,000 for your care. Well, they're going to want to get that money back somehow. And the way they get that money back, their only opportunity to get that money back is after you've passed away, if your assets are passing through the probate process. But with that irrevocable trust, none of those assets are passing through the probate process. They're going immediately to your children because they've been pre-designated, set up in an irrevocable trust. Okay? So Medicaid can't touch any of the assets when they pass from you to your children upon your death, or you or your loved ones upon your death. And therefore, you've just saved the full value of all of the assets that you transferred to that irrevocable trust. And that's how we protect property. So an irrevocable trust is an incredibly useful tool, okay? And it's important to understand that a revocable trust is a very useful tool as well. So, one exception with the revocable trust that you need to understand though, is that even though the assets that you put in there pass outside of probate, there's one big exception with regard to Medicaid being able to go after the assets. So with a revocable trust, if you receive Medicaid and your assets are in the revocable trust and you pass away, they can still go after the assets, okay? It's very, very important for you to understand that. Your revocable trust is not going to protect your assets from Medicaid estate recovery. However, a revocable trust, I'm gonna keep doing that, mix them up. A revocable trust doesn't take the property out of your name either. So a revocable trust is not the best thing for Medicaid for long-term care planning. Now, that being said, maybe you don't want to give up your control right now. Maybe you understand that, hey, I'm only giving up a measure of control. I'm setting the rules for the game, and I'm appointing a very trusted individual as my trustee. And so therefore, I still have a decent amount of control over the assets, but I still don't want to do it yet. I'm not ready yet. Well, there's a happy medium there, because I understand the extremes of the two, right? You have the revocable trust that you have the benefit of avoiding probate, consolidation of assets, and everything's easy peasy, and you still have all of that control. On the other hand, you have the irrevocable trust that is incredibly protective of property. It allows you to qualify for Medicaid paid for long-term care, and ensures that the property passes outside of probate and cannot be taken after you passed away. But you lose some control, right? So you have control versus protection there. So we want a happy medium, right? Those are the two extremes. So the happy medium is this: a convertible trust. A convertible trust is something that we've created that starts out as irrevocable and starts out as revocable. Told you how to do that. Starts out as revocable and converts to irrevocable upon some triggering event. Okay, so a triggering event is, number one, you could just decide to make it irrevocable, right? You could understand that, hey, my health is failing, could need long-term care within the next 3 to 5 years. I'm going to go ahead and make this trust irrevocable. Other than that, it would automatically transfer from revocable to irrevocable if something were to happen to you where you would likely need long-term care within the next, immediate future. So a diagnosis of a debilitating disease such as dementia, multiple strokes, or a debilitating stroke, some type of, terminal illness, things like that would likely result in a lot of medical bills. You want that trust to just convert like that to irrevocable, go ahead and protect those assets. You already have your beneficiary set up. You already have your secondary trustee set up, where you know what's going to happen, right? You know that you have the beneficiaries, those can't be changed. You know that you have the secondary trustee, so if it converts to irrevocable, then someone other than you and your spouse is now the trustee, and they're now the ones taking care of the trust. And that's how you have your cake and eat it too with regard to trust. So you get to maintain all the control as long as you're able to, and then the trust converts to irrevocable at such time that you're no longer in the presence of mind or the state of health where you should be the one controlling the trust anyway. Now, as long as you have this protection buttressed with the further protection of having appointed a healthcare power of attorney and general durable power of attorney, also known as a financial power of attorney, it's, that would be an incredibly robust estate plan for many, many people. Okay. And so the trust obviously is an incredibly flexible thing. As you've heard, you have two types of trusts that you can use, and they can be used for any number of different things. Built into the trust that we create are tools for, tax avoidance, especially estate tax avoidance, tools for ensuring that your assets go to the right people in the right way as well. That's another point that I want to talk about, because a lot of individuals may not want assets to pass just directly to their loved ones. Let's say I have a home. Let's say it's on, a farm, and that home and farm have been in my family for a number of years, and I want to make sure that if I leave it to my children, they don't just sell the thing, because I care about it. I mean, I worked hard my whole life. My father worked hard his whole life to cultivate that property and to build some type of operation for me, for his grandchildren, great grandchildren, that sort of thing. So I want to keep that in the family. Well, luckily, if I put it in a trust, I can dictate what happens to that property. I can ensure that, hey, this property is not going to go outright free of trust just to my son, my daughter, whatever, because I don't want them to have the ability to just get it outright. Now they're their owner and they can do whatever they want with it, because maybe they'll sell it. So I can dictate terms in that trust to ensure that they don't just sell my property upon getting it. That's, there for their children and grandchildren as well. What if I have a substantial life insurance policy that I put into trust and I'm going to leave it to my grandchildren? And I'm afraid that my grandchildren, if I leave it to them, maybe I die before they reach age 21. And if I leave it to them before they're 21, they're going to get a lot of money before they turn 21 and just blow it. Well, I can dictate that, hey, look, this money that's supposed to go to you is going to stay in trust, okay? And it's going to be available for your necessary needs, right? Just absolute necessary needs. So health, education, maintenance, and support. But otherwise, you're not going to be able to access this to just blow it, okay? And maybe you can get a little bit out every once in a while, but I'm not going to let you get it out in full outright until age 21, 25, until you get married, whatever it is, whatever stipulations I want to put in there, because it's my trust and I can control what happens to that property for generations to come. And this is how you build generational wealth, right? You might work hard your whole life and build something substantial. Maybe it's not crazy. Maybe it's not incredibly, a lot of money. Maybe it's not millions, but if you can control what happens to it for generations to come, allow that to grow, allow it to be preserved, you can create generational wealth without ever having made millions of dollars. And this is something that a lot of our clients want to do. A lot of our clients work. I mean, I would say every one of my clients that I've seen and built estate plans for work incredibly hard until their age of retirement. And a lot of times they don't retire until, 67, 70, something like that. They've really worked very, very hard for what they have, middle class, hardworking individuals. And, sitting down with those individuals and setting up an estate plan is incredibly gratifying, because I know that even though they haven't made millions, we can ensure that what they have worked for is preserved and can benefit their loved ones for generations to come. And that's, like I said, incredibly gratifying. And that's something that we can do through the use of a trust. So again, what is a trust? Trust is a tool. Trust is simply a tool that you can mold to benefit you in any way that you need it to benefit you. And the way that we set it up is with the most flexibility and the most protection possible for you, your situation, your family, the possibility for long-term care, which is incredibly important. Can't stress enough how incredibly important it is to ensure that you prepare for the possibility of long-term care, the possibility of needing some type of nursing home, assisted living, or in-home care, because it can be incredibly expensive. And, many, many people end up needing that type of care. Like I said, 70% of individuals, that's a huge number, okay? So if you want to learn about how to protect your assets, preserve your property, how to plan for the future, then we could absolutely sit down and talk about it. I'd love to. And, that's what I do every day. That's what I'm here for. That's, I eat, sleep, breathe this stuff. I eat, sleep, breathe protection of assets and property and protection of people, right? That's what I do as an attorney, and that's what I love to do. That's what elder law is all about. So if you would like to sit down and ask any questions about trust, then give us a call, 704-259-7040. In addition to this podcast, this video, we have lots of information about trust and any other thing that we do with regard to estate planning and elder law on our website. We have lots of blog articles. We have lots of videos. We also have a book out called Saving the Farm. We have another book coming. It's called The 10 Rules of Elder Law. That one that I've wrote it's 10 rules for protecting your assets and preserving a legacy. And it's one that I particularly love because I wrote it, but also because it's allowed me to synthesize, these rules that I've really been able to nail down for my clients over the years, especially with their, a lot of questions that they ask in a lot of situations that I've seen, just to educate you in the most simple, straightforward, but best way. So be on the lookout for that. That'll be coming soon. We've got to edit it out, and we're working on getting the, it just bound and printed and all that good stuff. So that should be out soon. We also have the Elder Law Report magazine in magazine form. If you like to hold something, read through it like the book, but a little less verbose than the book, a little less lengthy, we do have the magazine, and Elder Law Report 2022 is coming out soon. It's about to be hot off the press, and we're going to be sending that out to clients and potential clients. And then lastly, we have a lot of information on this podcast that I would suggest you go back and listen to the episodes. If this is the first episode you're listening to, please go back, listen to some of the other episodes. We have a lot of good information. Me and Greg McIntyre talk about a lot of different things that could help or interest you in a lot of different ways. So that being said, if you're interested, give us a call. 704-259-7040 is the number. We'd love to sit down with you, talk about anything you have questions about. And please visit our website at mcelderlaw.com. This has been Brenton Begley with the Elder Law Report.